Yes. Now, Miss Elliott.
Miss Smythe. Have we
Oh,
found
no. Good start. Miss Smythe. Forgive me, Miss Smythe.
Miss Elliott sits behind me.
So she does.
Probably be standing here.
Right. I apologise. I just misread the slip. I'm sorry, Miss Smythe. Yes, Miss Smythe.
My lords, my lady, I'm Miss Smythe. I appear on behalf of HMRC with Miss Elliott, who sits behind me, and Mr Burton, KC, leading Mr Rutledge and Mr Percy, appear on behalf of the respondent.
Yes.
The court should have a core bundle, a supplementary bundle, and an authorities bundle.
Yes.
And the court should have a main and a supplementary skeleton from us and one skeleton from the respondent.
That's right.
We've read, so you know, we've read all those documents, the judgment.
Actually, the whole of the core bundle, which is quite small, and we've looked at some of the relevant authorities.
I'm very grateful, my lord.
Now, is it right that this has turned into an academic appeal?
Yes, so that's what I was proposing to deal with first, was to tell the court where we are and then explain why we invite the court to hear the appeal nonetheless. But perhaps to see...
Is that a contested position?
My lords, my lady, no, not necessarily. There's just one observation to make about indemnifying.
Well, let's hear what the revenue says, shall we, Mr. Burton, and then
I'll deal with that first, and then depending on where we are at that stage, my submissions will be divided into 4 parts. But perhaps I can deal with that once you've heard me on this preliminary point. I'm grateful. So, where are we? The current position is set out in paragraphs 7 to 12 of our supplementary skeleton. The up-to-date position is that those instructing me have decided that the most expedient way of dealing with things is to repay the respondent a sum of money which has been taken from him as an overpayment. So the way that it worked was that he was viewed as having been overpaid because of the way that tax credits work. The award is calculated in advance. He was then regarded as having been overpaid. So because by then he had been transitioned to universal credit, money was taken from his universal credit by the Department for Work and Pensions.
Because he was mistakenly thought to have been self-employed at the relevant period.
Exactly. So that money will be paid back to him. What we need to do is confirm the precise amount, and we hope that that can be done quickly. But we just need to confirm the mechanics of it. But so far as his case is concerned, it is resolved.
Okay.
It should be resolved once he gets that money.
Right.
So as to whether you should hear the appeal notwithstanding, we've included Hutchison in the authorities bundle, and the court will be familiar with that. We can turn it up, paragraph 15. Essentially, there
Three
exactly.
stage test.
So can I start then, if I don't need to take the court to it, but it is at tab 15, could I start by, I'll make 5 broad points in relation to the conditions, if I may, and then 2 further points. So the first condition is that the appeal raises a point of some general importance. We submit that it does because it concerns the circumstances where a claimant enjoys a right of appeal if they've applied late for mandatory reconsideration. And
now, this is in respect of this provision, which is becoming gradually historic because the form of credit is being phased out.
It is becoming historic, but not everybody yet has been transitioned onto universal.
And there are you said there are a number of cases waiting.
There are 3 cases stayed in the first tier tribunal that we're aware of, and obviously there's potential to affect other claimants. I should just add that this case is cited as well as authority in this book, which is the Magic Social Security textbook. So, it is binding on first tier tribunals. So in that sense, we say it's a point of general importance. The second point we make is this, that certainly as we understood their arguments, we say it's striking that the Upper Tribunal's reasoning on the point of statutory construction is not actually supported by the other side. What they say is, well, it gets to the right result, but it gets there via the points in our Respondent's Notice, which are 1, vires, and 2, Article 6. But it doesn't, they don't, so far as we say it gets it right for the reasons it gives.
How do this point fit into the 3 Hutchison criteria?
That takes me to, that's my second point, takes me to my third point, which is that HMRC feel that they have no option but to come to this court to proceed because as well as the decision being wrong and indeed appearing to be accepted to be wrong by the other side, HMRC take the view that the decision isn't actually workable as it stands, and it's also binding at first tier level. So can I just flesh that out? We address it in paragraph 4 of our supplementary skeleton argument.
Well, I mean, unless I think hearing the headlines first. So you say it's unworkable. The reasons you'll explain if we get
the headline point is what it doesn't do is explain what you do in the first tier.
Yeah,
so, in other words, it appears to presuppose that the first tier can then jump to hearing the substantive.
Doesn't explain how the FTT would deal with it.
Yes, it cuts out the review stage, and certainly that's the view that's been taken by the first tier in Mr Arrbab's case.
Okay.
So, in other words, HMRC thinks some clarity is needed. Now, we've obviously given thought to what we could do if the court doesn't determine the issue because it decides it's academic. What would happen is we'd have to do the best we can in the first tier in another case, probably bring in another upper tribunal authority to say, well, look, you can't just go ahead and hear the appeal. You've got to allow us to make the mandatory reconsideration decision and then fight it out in a different case in the first tier. But that's somewhat messy because the first tier is going to be bound by this tribunal's decision.
Okay.
So that's that. The second condition is that the
respondents mustn't be at a disadvantage.
Yes, exactly. Well, the personal position is not affected. That's I haven't had any discussion with the other side about costs, and I would need to take instructions on that. But he's not prejudiced in the sense that he's going to get his money.
Well, if we just look at what Lord Newberger, wasn't it? So
yes.
Or was he still the MR? It was Lord Newberger. In Pop Dog at tab 15.
376. So
okay, so we're on to the respondent to appeal agrees to a proceeding, or is at least completely indemnified on cost, is not otherwise inappropriately prejudiced. So, doesn't the well, we'll have to see what Mr. Burton says. But
yes.
I imagine he may well say, well, I want to be indemnified in costs.
He may well say that, and I'm taking instructions at the moment.
Right. Thank you.
So that was effectively my fault.
I'm slightly surprised for my part that this hasn't been sorted out. No, I mean it's something which we've been thinking about.
Yes.
Because I'm disappointed that it's not been resolved before you stood up. Anyway.
Yes, I'm sorry.
We're getting instructions now.
I'm sorry, my lord, that we haven't. I hadn't understood the other side to not be content to press on, and we hadn't been asked to indemnify them in costs.
Okay.
I have had some initial discussion, but that's the first time I've been asked about that this morning. So I apologise that we also didn't give thought to that ourselves. We have been quite focused on how best to deal with Mr Arrbab.
But this also links to the third point under
Indeed.
Pop Dog, because under Pop Dog, the third point is it's got to be fully argued.
Yes, and certainly on the statutory construction point and ultra vires it will be, but you'll have seen, the court will have seen that in relation to the convention point, our position certainly is that as that wasn't fully dealt with below, it's very difficult for us to deal with it now, because there isn't...
So I think there are two separate points. If you don't indemnify the respondents, the question is whether they're going to be here to argue either of the first 2 points.
Yes.
So that's one point about going to the question of whether both sides will be fully and properly able to ventilate the argument.
Yes.
And then we've got the separate question of Article 6. The two are not the same question.
No, indeed. Certainly on the first point, which is the second condition, I think I need to hear from Mr Burton on that point.
Okay. Can we focus on the human rights argument?
Yes.
You say we shouldn't hear this because it wasn't argued below, and the court it would be much better for the court to have before it, the Court of Appeal to have before it, a judgment of a court of a specialist tribunal below on this very issue. And secondly, had it been taken below, you'd want to introduce evidence.
Precisely so, my lord.
Would you be able to argue the point, despite those disadvantages, if we wanted you to?
Not very well, because I don't have any evidence. So to the extent that the court decides that there is an interference which needs to be justified, all I can do is make very general submissions about time limits, and what I can't do is say, yes, but in the special context of tax credits, those instructing me have thought about it, they've thought about the judgment in CG, but here are the reasons for thinking in the special context of tax credits, this is justified, and that in my submission, we certainly do not take this point lightly. Can I make that clear? Those instructing me want this sorted out, but they're obviously equally concerned about the law heading in the wrong direction. And
Are they completely discrete, the vires points and the Article 6 point?
They are in my submission, because the point is not taken, or certainly not in the skeleton, that the construction should be different because of Article 6. The point is made that this court should make a declaration of incompatibility. Now, in our submission, if the court's to make a declaration of incompatibility, that it really needs evidence as to the system as a whole. Well, at the moment, it's got the isolated facts of one case where this respondent, we say, given his particular facts, would have had a remedy in judicial review. But so far as the court's being asked to declare that this system is incompatible with Article 6, there is very little before it to assist the court. There's nothing really from the Upper Tribunal. We don't have evidence from those instructing me to say, well, hold on, here are the sorts of situations we get in practice. This is why we feel that this is necessary. And certainly, I think it's right to say that the point is of sufficient concern to those instructing me that if the court thinks it can't divorce that point, then I suspect that my instructions will be, well, we better go back to the first tier, muddle through, and have this properly argued at the Upper Tribunal. It's obviously a point of significance for the department that instructs me, but obviously Article 6 decisions from this court are also liable to have broader effects, or to be at least to be cited in other cases. So we might add, and we certainly don't criticise the other side for this, but we're still not precisely sure what the case is that we're facing on Article 6. We've made that point in our skeleton. There are less than 2 pages of argument from the other side on Article 6. Nothing from the tribunal, and that makes it very difficult for us to deal with it in a proper way.
Well, would it be open to us, also we've talked about this, would it be open to us to hear the argument before deciding whether or not to deal with the Article 6 point?
Yes.
Just so we hear what Mr Burton, how he puts it. In other words, we'd allow you to keep your powder dry, as it were, on the points you've made about it. But hear how Mr Burton puts it, and then hear you in outline, as it were, on doing the best you can on what you've got, and then decide when if we want to rule on it on the basis of what we've got, or take you up the course you propose.
Yes, and indeed we say in our supplementary skeleton that if we certainly considered that the court might want to say, we've heard the argument, but we can't determine this for the following reasons, but it's a live issue for another case.
Right,
where
okay.
HMRC can put evidence in.
Right, that's very helpful. Okay. Anything else from anything else you want at this point? Or should we have Do you want to hear more from her? Yeah, okay. Thank you, Miss Smythe. Yes, now, Mr Burton.
My ladies, my lords, in relation to the second consideration in relation to indemnification, obviously the respondent is in receipt of legal aid at the moment. That's not an indemnity, it's a loan subject to a statutory charge, and therefore on behalf of the legal aid agency I'm really duty bound to invite the court to invite my learned friend really to agree to indemnify his costs, because otherwise a legal aid board is potentially picking up the bill for this case, which is inappropriate in the circumstances. So on that point, that's all I really have to add, and it may be that's resolved swiftly if my learned friend gets instructions that we need. Do you want me to address you on the other questions related to Article 6? Or?
Yeah, yes. I mean, what do you say to the course I was proposing to Miss Smythe, that we hear it before deciding whether we're going to deal with it?
I'm certainly content to take that course, and there is a decision before you of Connor, which I will be taking you to in due course in several respects in relation to Article 6 and indeed more generally. And the process there taken by Mr Justice Swift was to invite the Secretary of State to file some evidence after they'd heard oral argument to see if it made any difference, and I think invite written submissions in relation to that. We may not get to that stage, but at least that's one practical way of addressing the problem.
Well, Mr Justice Swift would have been sitting at first instance.
I do understand that.
I assume.
Yes.
He may be sitting here.
Yes, it was a judicial review in that case, I believe. Yes. I accept that, but that's one potential possibility. I mean, obviously, I understand that my learned friend would have to persuade the court to give her permission to adduce evidence in this appeal if it became necessary. I'm just flagging that as one potential option if it got to that stage.
All right. Right. Assuming you can get instructions quickly, Ms. Smythe, what we're inclined to do is to rise now and wait to hear when you're ready for us. Hopefully that will be, hopefully
Speedily.
a phone call will be sufficient.
Thank you, my lord.
All right, people.
Do you know how long it will take us to get? Well, a lot more.
No, not in a way that I could be helpful about. I mean, I can do my best.
But
There's funding for 2 not 3, and I don't think my involvement. Probably more. Yes, I'm assuming so. I mean,
that's when we came in anyway.
are you wanting your cost win lose? Is that what you're asking for? Your cost win lose?
well, that is what I do.
Yeah.
It's not indemnity costs.
No, I know it's not indemnity costs, but yeah.
It's. I mean, if we're arguing this because it's academic, I mean, I'll be straight with you. We'll be asking for our costs anyway because of the fact that very belatedly you've realised that.
Well, we've got things to say about that, given the way that.
Of course, I'm just making you aware that that's coming anyway.
Yeah.
So we're going to have a big fight about that.
Yeah. Fine. Okay.
So,
well, I mean, yeah.
I mean, it seems to me. Well, obviously it's a matter for you to take, but I mean.
Yeah.
In other words, you could say we're not got instructions for that and end up in exactly the same position without making a argument.
No, I'm ready to argue costs.
indemnify. You can't see. We're not going to do that, but
On the figures,
that's what the law seems to be saying.
on the figures we're being told 3,709.13, and then there's an extra sum because he's got a debt to something else. But we're going to need to confirm that in writing and just explain exactly how it's come about.
He's got another debt owed. Isn't that separate from this thing?
I think when overpayments are, it first goes towards any debt.
Another
you've got
debt
for something
to
else.
revenue and custom.
No, to the other thing, I think. But I'm just looking at it.
It might be cleaner to give it all back to him and then let them recoup what they did, because he's confused enough as it is.
No, I understand.
I'm
I think
confused.
it may be out.
Right, it's useful to have a figure that's making some sort of sense.
You ready?
Good chair.
Yes.
Court rise available.
Yes.
Yes, my lord, I apologise again and thank the court for the time. I have instructions that we do agree to indemnify the other side on costs.
Okay. So the order would be costs on an indemnity basis to be assessed if not agreed?
Not on an indemnity basis, but that we pay the other side's costs regardless of the outcome.
Happy with that?
Yes, my lord.
Thank you. Right.
So
Good. So what we're inclined to do is to hear the full appeal without necessarily indicating, or we're not indicating, that we're going to decide everything. Is that...
Yes, I'm very...
It makes it a bit unfair, and I'm sorry if it does, but we think that's the right way to deal with it, because there is potentially an overlap between all the points.
Yes, I'm very grateful, my lord. So
if we're hearing the whole appeal,
yes.
how do you want to proceed?
So I was proposing first to deal with tax credits legislation in general, just to make some preliminary points on that.
Right.
Second, to deal briefly with why we say our primary ground of appeal is made out. Third, to deal with the ultra vires point.
Yeah.
And then I'll make some very preliminary observations on Article 6. I can't really do more than that.
Well, you maybe want to say more in reply.
Indeed. Yes. Indeed.
Is Miss Elliott going to take any part in the...
Not on this occasion, but we're certainly well aware of the practice direction, all of us. So, yes.
Good.
So, could I then start with just some preliminary points on tax credits? I don't know how familiar the court is with tax credits. But
some of us are more familiar than others.
right. Well, there are essentially two types, child tax credit and working tax credit, and they are governed by the Tax Credits Act. I'll show the court how it works in the Act, but just to explain, there's essentially a distinction in the Act between an award of tax credits and entitlement to tax credits.
You cover this in your scope.
I have, yes. So essentially, you have an award during the relevant tax year and then check and determine entitlement at the end of the tax year. And then the declaration at the end of the tax year enables HMRC to determine entitlement as well as being a claim for the year ahead. So just to look at the Act briefly, it is in tab 2 of the authorities bundle. I won't go to all of these provisions, but just section 1 at page 8, which establishes the benefit. See section 1.1. And then if the court turns to page 18, this is the initial decision which governs the making of the award during the relevant tax year. So as I've said, that's based on circumstances at the end of the previous tax year, assessed by reference to the information in the declaration. So what happens at the beginning of the tax year, April 2018 to April 2019, Mr Arrbab is awarded a particular amount of working tax credit and child tax credit. If the court would like the exact figures, I can give those.
I don't think we need them unless...
No. So then what happens in that tax year, as the court will know, is that there was a telephone call as a consequence of which, and we've explained what happened, HMRC understood the respondent was self-employed. And then just dealing with the legislation and the facts at the same time, page 24 is section 17, and this deals with what's called a final notice. Where a tax credit has been awarded for the whole or part of a tax year, the board must give a notice. That's section 17.1. Section 17.2 says what the notice must require. And then the person obviously has to respond to the notice. So that's section 17. And then bringing in the facts of this case, it's common ground that this notice, section 17 notice, was issued on 25th of March 2019 with the wrong figures. What
Is this all done digitally now, or is it not 4 years ago? I imagine.
Done digitally.
It's now, it is, yeah.
4 years ago?
And was it probably not 2019?
We think it probably was done digitally even then,
okay,
but
right.
yes. So at that stage, Mr Arrbab gets the Section 17 notice with what we now know are the wrong figures on it. He was required to respond to that notice, and unfortunately, he didn't. Had he responded at that stage?
Sorry, when you say he's required to respond, is that the effect of 17 sub 2?
Yes.
That it requires a declaration, is that the point?
Yes, and then if your ladyship looks at 17.4, that says that the notice must either require that they declare income or inform the person that they'll be treated as having declared certain income, and then Section 17.5 is how the person complies with that.
Thank you.
And so it goes on, and the notice makes clear that it needs to be responded to.
Right. So you're saying in this case a notice was issued and not responded?
Yes, and that's common ground between the parties.
And presumably if it's digital, then there's a standard digital process which the declaration is rather old-fashioned in terms of, but it's actually just ticking boxes or filling in boxes.
Yes, and that's
just, but that's
this is why tax credits is so different from normal benefits, because you have this yearly system which you get the award based on the year before, and then the checking at the end of the year, and this is a crucial part of the checking process, and unfortunately it is a significant reason why things went wrong in this case, because at that stage, had Mr Arrbab said, oh no, you've got the wrong figures there, it might well have been resolved.
Have tax credits generally been an onerous
obligation on the revenue in terms of what's involved?
No more.
I mean, if it's an annualised process,
Yes.
it sounds as though a lot has to be done.
A lot has to be done, although much of it is based on the previous year and obviously relies on and has to rely on, like any system of benefits, on people telling the revenue if things are wrong or if things have changed.
Okay, thank you.
So that's section 17 notice, and for cross-reference, that's dealt with in our supplementary skeleton at paragraph 6.3. That's not an appealable decision, but it is nonetheless notice to the person of the basis of HMRC's figures, effectively. It certainly was in this case. And then section 18 is the decision on entitlement. That's on page 27 of the authorities bundle. So after giving the notice under section 17, the board must decide whether the person was entitled to the tax credit, and if so, the amount to which they were entitled for the tax year. And like tax, that's for the year just gone. So in this case, again, given the lack of response on the section 17 notice, the section 18 notice was issued with the same figures on the 30th of April 2019.
It may be me. Are these notices in the bundles?
They're not, because of the way that HMRC systems work. So the decisions are sent out. I see smiles. The decisions are sent out, but they're not on HMRC systems, so they can't be reproduced. The recipient has them, but as I understand it, and I'll turn my back to check this is correct. They can't then be reproduced now. This has come up in another case.
I mean, normally you can reproduce the form, but
Yes.
you haven't done that in this case.
No, none. They've not been before the tribunals below, and I think that's not customarily done. What happens is that HMRC will put in a response to the first tier with the relevant figures, but it doesn't produce or reproduce or reconstruct the notices, and that is the position in tax.
That's because it's digitised, is it? Is that why? Because they just
Well,
Yes.
it's digitised and then disappears.
Yeah, I think that's right. Yes.
I think what you would be able to produce is a screenshot from the revenue system showing that the document was issued on such and such a date. But
There are some screenshots in the supplementary bundle, right, but I hesitate to take the court there because they're not readily digestible, shall we say?
Okay.
I certainly couldn't read them anyway.
Legible. Okay, all right. So what you've told us is that the final notice was issued, the decision on final notice, section 18 decision was issued on the 30th of April on the same figures.
Yes, exactly. So that happens on the 30th of April. The other provision, just to show the court, I won't go to the appeal provisions at this stage because I'll deal with that in the next section of my submissions, but could I just invite the court to look at page 37? We address in our skeleton that there are different bases on which a decision, an entitlement decision, can be changed.
Yes.
And this is the provision on official error.
Sorry, where are you now?
Page 37, still
Section
in tab
21.
2.
Sorry, still in the authorities bundle.
Is that what's actually now happened?
No.
You haven't said, okay, it's an official error?
No, we haven't. We maintain it wasn't an official error. What we've done, essentially, as a responsible department, is as information has come to light in this case, we have looked back and said, actually, we can see that was wrong, but the way that we're dealing with it is discretionary, in effect, to sort out the overpayment.
Can I just ask what would be an official error then?
Yes, I'll turn my back to get an example,
Thank you.
if I may. In this case, I should say that the error was HMRC considers that it's not HMRC's error because the notice was sent, it wasn't responded to, and HMRC got the information.
So official error is a term of art.
It's a term of art. It's defined in regulations. We haven't troubled the court with those regulations.
I've already looked them up.
I mean, how can
You probably know them.
I struggle with that if we don't know what the notice said. I mean, was it apparent from the face of the Section 17 notice? Or would it have been apparent to the recipient that there was an error?
Yes, certainly that's accepted by the other side in their skeleton, as I recall it, because in their skeleton they say that it contained the figures that are wrong. So I didn't understand that to be in dispute. It is at paragraph 23 of their skeleton argument. Yes, so 2 examples, an error of calculation made by HMRC, or, for example, mixing this appellant up with someone else and saying that he'd said he was self-employed or had particular earnings when, in fact, Mr Y had said that.
So that, yeah, so official errors defined in the regulations. Ms Elliott's given you 2 examples of what they might be. But this is another error that's not a category as an official error. It's something that you've not a mistake you've acknowledged, and you're exercising some wider discretionary power.
The mistake we've acknowledged, in fact, goes to how we dealt with the application for the extension of time.
Okay.
But the way that we're putting that right is the way that I've indicated, and I'll explain that when I come on to deal with the next part of my submissions.
Fine.
So, just to put some flesh on the bones of, in case this is helpful to the court, there's an Upper Tribunal decision at tab 16. This is actually about whether not having a right of appeal against the decision that somebody hadn't made a claim for tax credits was contrary to Article 6. That's what this case is about.
Right, I'm just writing it down. Which page are we on now?
I'm so sorry, tab 16.
My mistake. Right.
The case of ZM. So, but the bit that I wanted to show the court is on page 386. It just explains the difference between social security benefits and tax credits and how they work. So could I just invite the court to read, for the whole context, the bottom of 385, paragraph 28.
28 and 29?
28 and 29.
Okay. Thank you. Do sit down. Thank you.
So the key point I draw from this stage is there is a difference between tax credits and social security, and it goes to what I said about why we would want to put evidence in.
Tax credits are part of the tax culture, as it were.
They are.
Whereas,
yes,
whereas benefits are part of the benefit.
They're a bit of a hybrid of both, but exactly that. They work in a very different way, as Judge Ward explained. And I make that point because it's important when deciding whether we can properly deal with an Article 6 point without evidence as to why we have the particular system we have in the peculiar context of tax credits. They're not the same. So principles set out and statements made in relation to benefits like employment and support allowance, which may be paid, for example, to claimants predominantly with particular illnesses, because that's the nature of employment and support allowance, can't be read across to this context, not only because the benefit is paid to different persons, but also because it's necessarily administered differently.
Yes.
So that's the first part of my submissions. I can then come on to the second part, which is to deal with our ground of appeal, which is to say why the Upper Tribunal got its construction of the legislation wrong. Could I ask the court at this stage to have out Miss Ward's skeleton argument? It's at tab 2 of the core bundle. So the ground of appeal is captured in paragraph 2 of her skeleton.
Yeah.
And the ground is that the judge erred in concluding that sections 21A to B and 38 of the 2002 Act permit an appeal to be brought if HMRC have decided that the period to apply for that review can't be extended. So at that stage then, back to the 2002 Act, could I invite the court to look first of all, and I will take these provisions out of order because it makes more sense to do that, to look at page 57, which is section 38 of the 2002 Act.
Yeah.
57. So starting with section 38(1, an appeal may, and then the words in square brackets which were inserted by the 2014 order, an appeal may, subject to subsection 1A, be brought against, and there are the listed decisions. So we've looked at section 14. The court will see that section 17 is not referenced there. And then,
section 18.
but section 18 is in B.
Mm-hmm.
And then 38(1A makes clear, and this is the crucial wording in this case, an appeal may not be brought against a decision unless a review of the decision has been carried out under section 21A. So a review has to have been carried out under section 21A, and notice of the conclusion on the review has been given under section 21A(3). So at that point then, if we turn back to page 38, which is section 21A, I hope it's
Section 38 is on page 20.
30, yes, page 38. I thought your lordship had a broken bundle from
No, I was just never mind. Section 38 and page 38.
Yes, confusing. I'm not sure my brain can cope with that actually. So section 21A. 21A(1) contains the obligation to review in the circumstances set out there. So the commissioners must review any decision within section 38(1). So the obligation is not to review generally, it's to review the decision within section 38(1). I've shown the court that provision. If they receive a written application to do so that identifies the applicant and the decision in question, and that application is received within 30 days of the date of the notification of the original decision, or it's received within such longer period as may be allowed under section 21B. Once that gateway is passed, the commissioners have to carry out the review as soon as is reasonably practicable, and then 21A(3), when the review has been carried out, the commissioners must give the applicant notice of their conclusion containing sufficient information to enable the applicant to know A, the conclusion, B, if the conclusion is that the decision, which of course is the decision within section 38(1, is varied, details of the variation and the reasons for the conclusion. And then sub 4 specifies that the conclusion must be one of the following: A, that the decision is upheld, and that of course again is the decision within section 38, or varied or cancelled. So that's section 21A. Section 21B is the discretion to extend time if conditions are met. So first condition is in 21B2. Second condition is that the application for the extension explains why the extension is sought, and there's a long stop date, it has to be made within 13 months. Third condition is that the commissioners are satisfied that due to special circumstances it wasn't practicable for the application for a review to have been made within the time limit, and satisfied that it's reasonable in all the circumstances to grant the extension. And then there's a mandatory factor to take into account at 21B6. So we say, very simply, that the clear meaning of those provisions is that a person cannot appeal if a review hasn't been carried out under section 21A. And that requires that the actual entitlement decision is reviewed and notice of that review has been given. It's not enough simply that there's a refusal to extend time, because if there's a refusal to extend time, the review won't have been carried out, because it's a condition that it has to be 21A2, it's received within such longer period as may be allowed. So in other words, what section 38(1)A mandates is the conduct of a review under section 21A1 and notice of that review under section 21A3.
So does it all turn on the words carried out, or is that too simple?
It turns on not just the words carried out, those are obviously very important, but it's a review of the decision has been carried out under section 21A.
Yes. Yeah.
And notice given under section 21A3. So it's not enough that a review has been carried out under section 21, which is official error. It has to be a review under section 21A and notice given under section 21A3.
So the three elements: carried out, under 21A, and notification.
Yes. So we can then look at the decision in this case. That's at tab 12, page 87 of the core bundle. Does the court have that letter?
I'm just making a note. It's 87, did you say?
87, tab 12 of the core bundle.
Yes.
So, thank you for the letter we received on the 9th of July asking for a mandatory reconsideration of the award notice. Just for the court's note, the letter is in fact a form, and that's at tab 13 of the core bundle. Of the award notice we sent on 30th of April, it notes that there was until the 30th of May to ask for mandatory reconsideration, and that was late. And then the key paragraph, although we can treat a late request for a mandatory reconsideration as made in time, we can only do this in special circumstances. That's correct. See section 21B. We can only do this if the request is made within 13 months of the decision. Correct. What we accept, though, that this decision did not do and ought to have done under HMRC guidance was engage with what the respondent had said about why he wanted time to be extended, and if time was to be refused, to explain why time should be refused. And we squarely accept that in our supplementary skeleton argument. What this letter then goes on to do is consider the discrete power to revise on grounds of official error. The reason it's a discrete power is that the time limit is different. There's a much longer time limit of 5 years to apply for a revision on grounds of official error. So if HMRC don't exercise their discretion under section 21B, they do go on to consider whether there is an official error, and that the letter then goes on to explain why the view was taken that there wasn't an official error. But the letter...
Well, it doesn't actually explain why there isn't an official error.
It asserts that there's been no official
Yes.
error.
In fact, it purports to confirm that there's been no official error,
Yes.
which suggests that somebody had presumably previously said there's no official error. Or is that just some sort of speak?
It may be speak. I don't know whether there had been any kind of conversation. No, but that's just speak. But we certainly maintain that there wasn't an official error. Where we accept that the letter was not acceptable and not in accordance with HMRC guidance was how it dealt with the application for an extension of time. In fact, we think that if one looks at that letter, if anyone reading it would think, oh, they think I've applied after 13 months. So it was that which then led us to think, well, that wasn't right. We didn't follow our internal guidance. We need to look again at the facts of his case, acting obviously as a responsible authority should. Hence the review of his particular facts and where we got to. But what we do say is that rightly or wrongly, was a refusal to extend time under Section 21B, and therefore it did not go on to conduct a review under Section 21A.
I mean, as a matter of fact, the letter at page 87 refers a little bit further down to the phone conversation, which we do actually have a transcript of it.
Yes.
In which Mr Arrbab said repeatedly, when he was asked about self-employed status, I don't understand what you're saying, my language isn't good, that's not right, and all of, I mean...
Indeed, my lord.
That's only a partial, that paragraph on page 87 is a very partial account of the transcript we've seen.
Yes, and those instructing me accept that his letter is not a good letter, and it falls below the standards which HMRC expect its letters should meet, which is why they've taken the approach they have in his case. And the court will see that I have people sitting behind me, and I can say that the facts of this case have been drawn to the attention of senior people at HMRC who accept...
But you say that still doesn't amount to an official error?
No, it's not, and I'm happy to explain to the court why it's not an official error, but it's not an official error, effectively.
Well, you say it's not within the regulations. Which we
Indeed,
got
and there is a whole series of cases on official error and when there is and isn't official error, and I don't in any way profess to be an expert on that and would be not inclined to dabble lest I lead the court astray. We can certainly produce a note on that, though, if that would assist the court.
Well, I think it's really just, it's more relevant to see how the lines of challenge, I'm trying to use neutral language here, lines of challenge to an administrative decision are cut off in various different ways.
Yes.
And I'm really just trying to understand, how that is.
And what I can tell the court is that a lot of thought was given as to the appropriate way of putting his case right, and as part of that consideration, thought was given to whether there was an official error and discussed carefully within HMRC, and the view is maintained that there was no official error for a number of reasons.
If there is an official error, the correcting process a mandatory reconsideration?
Yes, it's a review. What will either happen is that the decision will be changed if there's an official error, and then there is a fresh decision. I'm so sorry, my lord. I'm just turning my back. If there is an official error, the decision will be changed, and then there will be a fresh decision, and then a fresh right of appeal.
Just give me a minute, would you?
Well, I understand what you say about the regulations, that we haven't got the regulations on official error. It's obviously being considered. Neither party is saying that this is an official error, as I understand it. The greater concern that we all have is that it's taken to the doors of the Court of Appeal for, frankly, the transcript of the call to be read properly. and it to be understood what's happened in this case. And that message should certainly be passed back very clearly.
Yes, my lady.
I mean, it's your skeleton, isn't it? It was the first time it was.
Yes.
So that was last week.
Yes. Could I just say, by way of context, that at the time the application for permission to appeal was made, those instructing me were very focused on the point of principle, which is a matter of great concern for HMRC. There was then a long gap because there were delays in the other side either instructing counsel or being able to produce a skeleton argument. Once the skeleton argument was received, we reviewed the arguments and we also reviewed the case, called for more papers, looked into his facts in more detail. Now, of course, I accept that perhaps it's difficult because there have been a number of errors in this case. First of all, the non-response to the Section 17 notice.
Well, I think you can't put too much store by that. The point we're on at the moment is the writer of this letter had claims to have listened to the phone conversation. We've got a transcript.
Yes.
That it's undeniable that, as you say, that's not a good letter. There should be a major takeaway from this, that the procedures in place that allowed a letter to be written in this form are not, frankly, up to scratch.
Yes, my lady, yes, and we apologise for that, and we don't seek to defend that, which is why in our supplementary skeleton we accept, as we do, and have worked to resolve it.
I understand that. The more significant point goes to the number of potential appellants who may not have done what Mr Arrbab's done, and it goes to presumably training and management.
My lady, yes, and we can certainly provide the court if it would assist with the guidance. There are also template letters, and this letter was not consistent with the guidance or the template letters in my instructions, and it's highly regrettable, and that is accepted by those instructing me.
I mean, entirely endorse everything that's just been said. But there is the further point, just thinking, the problem started with the translation of the telephone call into the original form, which we haven't seen but which we've had a description of on the 25th of March, I think it was, 2019. And then the subsequent decision letter is a month later, I think. And that error, because I think it must be acknowledged that there was an error in the translation of the information that was given in the phone call into the two letters that we don't actually have copies of, is something which I think you portrayed at the start of your submissions as not an error from HMRC, because you put it, I think, on the basis that you just relied on the information you were given, and therefore it's the fault of the applicant, the fault of the recipient. And I do question that characterisation,
yes,
because I do think that a fair reading of the transcript indicates that the error was at the start that of HMRC.
Yes, I certainly hear what your lordship says about the transcript. My point, I think, is that it's not what's classified as an official error, but I would...
I'm not talking now about an official error. I'm talking about an error in the more general sense, because that sets the scene for the or the possibility that that occurs, sets the scene for the interpretation of the restriction on the rights of challenge,
yes,
neutrally, that we've got to consider. And I need to understand why you say that in this case the error was that of Mr Arrbab, not of the revenue in the first instance.
Yes, can I turn my back for a moment, because I just want to check the context and what else there may be that isn't just the conversation. Can I have a moment to turn my back, or else we can certainly produce... I hear the court's concerns, we absolutely appreciate them, and we that they are not. They have been discussed and are certainly.
I think this is quite an important point. We're all concerned about this.
Yes.
We think we should give you an opportunity, not now, but during the course of the day, to get proper instructions
Yes.
rather than just turn your back. I just like to add one thing. I know it's not helpful necessarily to get interventions from all three of us, but the context in which both of the points raised on either side of me has to be considered is that the type of people we're dealing with in this sort of case. Many of the cases we deal with, you must be dealing with, the revenue must be dealing with, involve people with vulnerabilities and who no doubt struggle to deal with these understandably complex provisions. Anyway, perhaps you might like to come back to the
Yes.
points that Milady and my Lord have raised when you've had a chance to take proper instructions later in the day.
Yes, I will do that. But could I just emphasise now that those instructing me are here. They are concerns that are already recognised, but they are listening to what the court is saying. I will come back with a detailed answer to the court's questions. And we fully understand why the court is raising
All right.
those points.
Thank you. Now, where would you like to go now?
So, essentially, it's this, that in reaching its conclusion on the simple statutory construction point, the Upper Tribunal relied on the decision of CJ, which the court will have seen in its pre-reading of the Upper Tribunal's decision.
Yes, we've all read CJ.
Yes, I don't need to turn it up. The submission we make is very simply that the wording in the social security context is different and couldn't lead the Upper Tribunal to the same conclusion in that case. And I can deal with this very briefly by taking the court to Miss Ward's skeleton argument at...
Tab 2.
Yes, back to tab 2 and at paragraph 15 and 16. And in particular, at the second part of paragraph 16, she notes the relevant language in the social security legislation, and the wording is, there is a right of appeal in relation to a decision only if the Secretary of State has considered whether to revise the decision under section 9. The argument in CJ is effectively that where an application for revision is made and the Secretary of State for Work and Pensions decides not to extend the time, the Secretary of State has considered whether to revise, even if the Secretary of State doesn't actually revise. The difference in the language here, as I've already submitted, is that what is required is that a review of the decision has been carried out.
Carried out under section 21.
Yes.
Hey.
So that's the submission. That's all I really have to say about our ground 1. We say our ground 1 is made out, and I suspect that is why the other side have answered not by defending the Upper Tribunal's decision, but for giving different grounds. There is a point... I'm so sorry, my lord.
I was wondering whether you were going to take us to the Upper Tribunal decision, just so we get a little bit, if it's there, a greater understanding of why they reached.
Yes, I'm very happy to do that.
The UTJ reached the contrary conclusion.
So it appears at tab 6, page 62 of the core bundle.
Yeah.
Now, and we draw attention in our supplementary skeleton argument in paragraph 4 to the start of this decision, the directions that are given at paragraph 2, which is the first tier tribunal must hold an oral hearing, and it has to decide whether to extend time to permit the appeal to take place and then consider the merits of the appeal.
This goes to your there's no remedy point.
Yes, it goes to the point that where's the interim bit that the legislation requires, which is that HMRC reconsiders its decision. That's the way that the first tier tribunal has understood it, because the court has in the supplementary bundle the follow-on decision from the first tier, which is at tab 10 of the supplementary bundle.
Okay. Do you want to take us?
I can capture what
Okay,
it
let's-
says.
Sorry, they've interpreted it as miss out the review. If you extend time, you go on straight away to consider the merits.
That's certainly the way I read its decision. Tab 10 of the supplementary bundle, page 21. So it's the end of paragraph 2. Having considered the reasons for lateness, I've extended time so that the substantive merits of the appeal can be considered, and then the respondent is directed to provide a submission on the substantive issues rather than to actually go away and conduct the review. So in a sense, there are two errors. There's the wrong construction of the language, and then there's the consequences
Review's
of that
missed out.
construction. Yes.
So, are you saying this exposes a flaw in the Upper Tribunal's reasoning? That
Yes.
not only is paragraph 2 that the direction's wrong, but it also exposes that it's another string to your bow in your argument about the interpretation.
Yes, it's
Because
why.
there, in fact, on a proper analysis, you say there isn't a remedy afforded in this way.
Yes.
Yeah. Okay.
Well, put it another way, I think you would say it undermines the need for a review mandate. You no longer have a mandatory review.
Yes, it in effect cancels out that requirement, which is a clear requirement on the face of Section 38 and Section 21.
Mandatory.
I mean, see what's said against you, but I mean, it might be simply said that the whole ethos of this legislation is to give HMRC the opportunity to conduct a review to avoid excessive numbers of appeals. But if wrongly you don't conduct the review, or don't and decide not to extend time for the review, in a sense, that's your problem. You passed up that chance. So why shouldn't the citizen go straight to an appeal?
Well, there are two discrete points in my submission. The first is what the legislation says, and the second is the view that some may take as to what the legislation should do. On the first point, legislation is clear that the review has to be conducted. Now, there is a solution to this. If, for example, this court had not heard this appeal, we would have to have gone to the first tier and said, well, okay, we're stuck with this decision in this tribunal, but we're going to draw your attention to a different Upper Tribunal decision, which emphasises the fact that the first tier shouldn't be deciding the case without a mandatory review. So Judge Scolding's decision has to be read subject to this other Upper Tribunal decision, which...
Well, it's obiter, is it?
I'm so sorry.
It's obiter. Is it? Is that what you're saying? What she says it to?
No, it's not. I mean, it's the
wrong.
direction she gives. It's wrong.
It's wrong.
But we in response to your lordship's question, we say that the legislation says there has to be a review conducted. So the solution, if the first part of the reasoning is right, nonetheless the direction is still wrong, because the direction should be HMRC to conduct a review.
Okay, right. Okay.
Well, but you only have to conduct the review in accordance with Section 21A.
Yes, but it has to be conducted. So the way that it would work is HMRC go away, does its review. It might sort out the appeal altogether. That would be the plan. And if it doesn't, then the substantive appeal goes ahead. But that's the messiness, we think, of trying to fit the social security solution to this legislation, which says something different.
That mess says you're going to the FTT twice. One, the logical consequences, once to extend time, and then, I mean, it's a conceivable consequence.
Yes.
Because there could still be an appeal following the mandatory review.
Yes.
A further appeal.
Yes.
Okay. And that's the thing I want to say on paragraph 2. The reason I asked you to go to the UTS decision was because just to see if there was any, we could put flesh on the bones of their reasoning.
Yes. So
their reasoning, I'm sorry.
The decision is structured, obviously the introduction and the background, the first tier decision, the Upper Tribunal, I don't need to take the course of that. There's then, under the legislative scheme, a description of the provisions. Paragraph 17 deals with, the wording is not identical, but they both have the same underlying statutory purpose.
Right, let's just have a look. So
Sorry, I've lost my place. Where are you?
I'm in tab 6 of the supplementary bundle,
Page
paragraph
60
17,
Well,
page
66 is where she acknowledges the distinction.
yes. So page, and then on to page 67, paragraph 17. There is reference to the statutory purpose. There's then a reference at paragraphs 18 to 20 to CJ.
Yeah.
There's then a reference to the mischief at paragraph 21, and the point made in Miss Ward's skeleton, which we maintain, is purpose cannot detract from the clear wording of a legislative provision. And then at paragraph 23 and 24, the conclusion there is to ignore, we say, the wording of the legislation, and to say this can't have been what Parliament has intended given the explanatory note. We say, but it's what the legislation says.
You don't go to the explanatory note.
No.
Clarification if the legislation is
Well,
clear. Is that what
yes,
you're saying?
I mean the explanatory notes, correct me if I'm wrong, what they do is emphasise the importance of the review.
Yes.
It's questionable how much further than that they go.
Yes.
They're not part of the legislation.
No.
Explanatory notes.
No.
They're
They
explanatory notes.
can be considered for mischief purposes, but of course mischief can help the court construe something which is unclear. The mischief does not entitle the court to disregard the clear wording of legislation, and we say the wording of this legislation is clear.
Yeah.
And then paragraph 25 is a conclusion that a substantive review has been carried out. I've already dealt with that because I've said what happened was that a decision was made not to revise on grounds of official error. But there was not a review within section 28(1)(a). And then paragraph 26.
Does she actually decide whether
No,
a substantive review is?
it's not.
She just says,
Maybe, yes. It's,
Maybe.
I don't think there's a clear finding
no,
that there had been a decision
no.
pursuant to 21A, which would fulfil the requirements of section 38(1)(a). And then there is a construction of the statutory language at paragraphs.
That's sort of even if I'm wrong about, in a sense.
Yes.
Isn't it?
It's because if the judge had found that there had been a review, the rest of it would have been academic
It's not-
because.
no, yeah, it's not
It's
right.
just raising it as a question, I think.
Yes,
agree.
I think so.
Sorry, you're right.
Yes.
And then she has regard to the factors,
Yes, as regard to factors.
including Article 6.
Yes. And what we say about, again at paragraph 27, we were not sure whether that was premised on a review having been carried out. We also, although there's reference to Article 6, we couldn't take from this any detailed reasoning about Article 6, the requirements of Article 6, why Article 6 was breached, and so on. And one would submit that in a case where the Upper Tribunal is considering making a finding of this nature, that there has been a breach of Article 6, that it would be sensible to have an oral hearing on the point.
Sorry, was this not an oral hearing?
No, it was not, no. What
it's
happened,
on
it was all done on the papers, and we haven't, what we've been able to discern is that there was an application for permission to appeal, which was brief. It mentioned the case of CJ. HMRC then put in submissions, and then there were some further brief submissions from the respondent, and shortly thereafter we have this decision. What I
Okay.
can't say definitively was whether HMRC was asked at that stage whether it agreed to there being a decision on the papers. But we certainly, with hindsight, should have perhaps pressed for an oral hearing, or the Upper Tribunal might have canvassed that with the parties. I don't understand that it did. But this was a decision made on the papers on the basis of very brief submissions, which is part of the reason why we are so concerned that there hasn't been proper consideration of the Article 6 point. And it's certainly not there's no detailed consideration of it at this level. Indeed, the judge can't be criticised for that because she didn't have submissions on it.
Well, Presumably, I mean, JC refers to Article 6, doesn't it?
It does refer to it,
That
although
may
there,
be
of
where
course,
the point has come from.
yes, the statutory language is different and the system is different.
Well,
So-
do you want to say anything about her sentence? I consider that fails to grapple adequately with the decision letter, which does implicitly seek to uphold the decision.
I think I read that again as either a finding or just a suggestion that Section 21A had been met, but it
Yes,
isn't clear.
She was saying, I think, wasn't she, that you had in fact carried out a review.
Yes, I think so.
That's-
But that if so was we weren't entirely clear because it would have made the rest of this irrelevant. Because if we carried out the review, then the right of appeal would have flowed.
Anyway, it's a review. You carried out a review under Section 21A.
We hadn't carried out a review, we say
Yeah.
under Section 21A, yes.
So it's not. You say that given those, or do you say?
We do. Yeah.
Given those additional words under Section 21A is one of the 3 points that Milady points out.
Yes, exactly what we say.
And that even if it is possible for the phrase carrying out of a review simpliciter to include failing to grapple with the issue, that's interpreted isn't open because the review is not an unqualified review.
Yes,
It's
exactly.
a review under Section 21A.
Exactly.
So that's very long-winded. But you get
Not at all. Exactly so, my lord. There's then further 28. Paragraph 28 deals with Article 6 to some extent, but not in any we say meaningful way, and certainly nothing that allows us to really answer it. And then paragraphs 29 to 35 set out the reasoning. There's a reference to Salim, although my learned friend may take you to that case. That's a case on very different facts. There's a reference to there being interference with a fundamental right, and so there needs to be absolute clarity that the rule or regulation authorises that interference. We say there is absolute clarity on the wording of the legislation. Then there is discussion about Parliament can't have intended this. But again, that I've already made the submission about that. That's not the question. The question is, first and foremost, what does the legislation say? And Miss Ward's skeleton cites, and I'm not going to take the court's time with this, but cites the British Citizens case. But there have, of course, been a number of cases of the Supreme Court which say, well, you start with the language. That's,
Sorry, which case is referred
it's
to?
the PRCBC case. For the court's note, it's at tab 24 of the authority.
Thank you.
And the key paragraphs are paragraphs 29 and 30.
But you say that's one of a number.
Yes, there are,
Yeah.
are a number which
I
say,
think we have this. 29:30, is it?
yes,
It's Lord Hodge, isn't it? Yes.
yes.
Yeah, I've certainly looked at this very recently.
Yeah. I think there's something even more recent than this, actually.
There are, yes. There are a number of.
Well, as I say, it's certainly been raised in the last month in front of me, and it may well be that judgment's been handed down. But this is Lord Hodge in some yes.
Yes,
Some authorities refer to it as O rather than the.
that's right,
project.
yes. O is easier to say. That's what I should have done.
And anyway, you say it doesn't. That
Yes.
the test for considering material out with the legislation itself, the statute itself, laid
Yes.
down or not laid down, but explained here.
Exactly. And
Is not that test isn't satisfied in this case.
yes, it's captured in Miss Ward's skeleton at paragraph 28. External materials can't displace the meanings conveyed by the word of a statute that are clear and unambiguous and don't produce absurdity. The literal construction is clear and unambiguous, which is that this review has to be carried out. So the judge, I mean, these are precisely the points that might have been debated at an oral hearing. And the fact that it was on the papers reinforces our concern about this court effectively sitting as a court of first instance on an Article 6 point. There is then, at paragraph 32, a reference to a high risk that many people with good claims on the merits will meet a time limit. We say that that is something for evidence. And at paragraph 33, there's reference to frustrating the purpose of the legislation. We say there's no frustration of the legislation. HMRC is sticking by its terms.
Could you just go back to paragraph 30?
Yes.
And maybe I missed it when I was looking at the project case, Lord Hodge. But do you want to say anything about the last part of paragraph 30? As it were, the consequences. What the
Yes,
UTJ says.
I think fundamentally, again, we would say
And 32, yeah.
we would say that to the extent this is being cast as a systemic point and a systemic challenge, it needs systemic evidence. Certainly in this court. The question before the upper tribunal is always this particular appellant, rather than a general systems-based challenge to legislation, because what it's dealing with is a discrete issue about the benefit entitlement of a particular individual. But to the extent that there is to be a systemic type challenge, for example, in an Article 14 challenge in the upper tribunal, there will be that type of systemic evidence. So the government department will put in, to justify any difference in treatment, it will put in detailed evidence to explain its position. And in that sense, and the upper tribunal, and indeed the first tier tribunal, can get into those systemic type issues. But we would submit that those are precisely the sort of issues which need evidence from HMRC, because we need to be able to say, look, this is the tax credit system, this is why we've decided to maintain this system. People get an extra bit of time because of X, because they get their Section 17 notice. These are the sorts of appeals that we see, these are the figures.
I mean, are you saying that the upper tribunal judge was wrong in any of the concerns that she raised, in paragraph 30 to 32? I mean, is she wrong to say that, for example, many individuals wishing to appeal are vulnerable and may be unwell for periods of time? I mean, why is she entitled to express that view from her own experience and knowledge? Isn't it obvious?
She's perfectly entitled to express that view. What it can't do is change the clear wording of the legislation, which is my submission under ground 1. And insofar as this court is considering an Article 6 argument, right, HMRC needs to be able to respond to these points. And I don't say that lightly, but this is about ensuring that the court reaches the right result on a point of significance. And it's right in my submission that a department must be able to set out its position in evidence on these kind of points, and perhaps counter them with other points, which is I don't have the evidence, so I'm just making general points here, but it might say there are some claimants in this position, but actually there are other claimants in this position, and overall, making a decision about what we think is the right approach, we take this approach because those are the sorts of things that might go in evidence. I can't take it any further than that because I don't have the evidence, because it wasn't dealt with below.
I mean, to what extent, well, we're going to come on to the vires argument, I think it's onto it in any
yes.
event. I mean, some of these points are not irrelevant to the vires argument, are they?
We submit that they are, because there's clear vires, and Total makes clear that there is vires. That's our answer to that.
Yes. Thank you.
So that is our case on our ground.
Oh, yeah, the ground. And
yes.
now we're going to vires.
Yes, we are, yes. So this is addressed in our supplementary skeleton.
Yes. Thank you
At
very much.
paragraphs 15 onwards. Now, again, it may be that most of the points some of the points I need to deal with by way of reply, particularly in relation to points that we have made about remedy. What I was proposing to do at this stage was deal with the core point, which is that we say there is vires, and there was vires under section 124.
So you're going to take us to the statute?
I'm going to take the court to the statute and then to total.
Yes.
So, paragraph 18 of our skeleton, though, we say this is important, that one can't simply say all the legislation is ultra vires. It's necessary to identify precisely which provision is said to be ultra vires, because that's the provision that it's being said the court should disapply. And that's the point we make at paragraphs 18 and 19. And it's addressed separately in our paragraph 25 when we deal with remedy. One has to be precise about this. As we understand the case, it is the provisions, not section 38(1)(a), but rather a complaint about sections 21(a) and 21(b). But those provisions, as a matter of vires, we say, are clearly within the scope of the enabling power.
My lords, my lady, just in case we might go wrong here, I don't believe there's any ambiguity about which provision we're saying is ultra vires from the skeleton. I just wouldn't want us to waste time looking at the wrong provisions. It's very clearly 31(1)(a) that we're contending is ultra vires. 38(1)(a).
So section,
paragraph 11 of the skeleton.
Section 38(1)(a). So that may be our misunderstanding of the skeleton. So the complaint is, it is ultra vires the enabling power, as I understand it, and again Mr Burton will correct me if I'm wrong, it is ultra vires the enabling power to say that an appeal cannot be brought unless a review of the decision has been carried out under section 21(a) and notice has been given under section 21(a)(3, that is ultra vires.
Right, so yes? What do you want to show us?
So, could we then turn up tab 3, section 1241.
This is the Finance Act 2008.
Yes, so 1241, the Treasury may by order, made by statutory instrument, make provision, A, for and in connection with reviews. The wording for there is significant, as we'll see in a moment.
Yeah.
And in connection with appeals against HMRC decisions. And then 2, an order under subsection 1 may in particular contain provision about A, the circumstances in which, or the time within which, a right to a review may be exercised or an appeal may be made. And we say simply that section 38(1)(a) makes provision for reviews and in connection with reviews. And it also contains provision about the circumstances in which, or the time within which, a right to a review may be exercised.
Sorry, you say section 38. Sorry, say that again. You say section 38 makes...
So what it does, by cross-referencing, an appeal may not be brought unless a review of the decision has been carried out under section 21(a) or 21(c).
Sorry, what I don't understand is the submission that section 124(1)(a), sorry, that section 38(1)(a) makes provision for a review. It doesn't, does it?
Section 21,
Yes,
A and B.
What it does is say you can't bring an appeal unless a review of the decision has been carried out under section 21(a).
Yeah, but sorry, I thought your submission, you were just looking at section 124(1)(a).
Yes.
And I thought you emphasised the word for in section 124(1)(a) and said that section 38(1)(a) made provision for a review.
That may be, because certainly, as I understood it, although the focus is on section 38(1)(a), the real complaint is about its reference to section 21A, and it may be that I have to hear precisely how Mr Burton puts the case.
All right. Well, he's given us an indication that he's focusing on 38.1a.
Yes. So,
The point, the emphasising of 4, and which to some extent covers what we were going to say about Total, relates to review. Section 24.1a about reviews, where it looks as though we're dealing with section 24.1b.
yes, and it does squarely make provision in connection with appeals against HMRC decisions, because it makes provision about the circumstances in which an appeal may be made. In particular, an appeal may not be made unless a review.
So I understand I understand a submission that section 38.1a makes provision in connection with appeals, which is under section 124.1b.
Yes.
But I thought it may be just I misheard or you spoke very fast. I thought you were making a submission under section 124.1a.
Yes, that's my fault, because I'm afraid I'd understood, and that would be evident from paragraph 19 of my skeleton, that insofar as the attack is on section 38.1a, it's section 38.1a read with the requirement in section 21a. If that's wrong, I accept that it's section 1241b, provision in connection with appeals. Section 38.1a is making provision in connection with appeals against HMRC decision.
But I'm just trying to get your case straight. In a sense,
Yes,
forget the
although
time. What do you say the enabling power that was used to justify section 38.1a?
That will be section 1241b,
Right.
section 1242a2, but the section, one can't just divorce, in my submission, bits of the legislation, because the thing has to be read as a whole. So in terms of the vires, when one is construing legislation, it is relevant that section 1241a confers a power to make provision.
I understand. I would understand. Okay, let me see if I got this right. Section 38.1a says you can't appeal unless you have had a review of a decision under section 21a.
Yes.
Now, in a sense, if section 21a is not authorised, then I
Yes.
follow that section 38.1a wouldn't be either, because it's interdependent. And so I understand a submission that says that your authorising power for section 21a is section 124.1a, and your authorising power for section 38.1a is section 124.1b. Is that actually what you're saying?
Yes.
Right. Okay.
Yes, and I'm afraid, but we're in a slightly odd position, because I'm responding to a new argument in sort of the wrong way round, if you like.
Is it? I mean, I think it may well be. We would need to perhaps to hear Mr Burton first before we go much further. But it doesn't say 24.1b does not say for and in connection with appeals.
No, but then the key point, and I will rely on Total for this, is that it says in 1242a2, an order may in particular contain provision about the circumstances in which, or the time within which, an appeal may be made. And we say that's squarely what section 38.1a is doing.
But that's only if you've got an order which is justified under subsection 1.
Well, section 1242a2 is the
Yeah, it clarifies the circumstances in which an order under subsection 1 can be made.
yes, exactly.
It says it can be made in particular
Exactly.
in the following circumstances.
And as the court says in Total, that doesn't mean it can't be exercised in other circumstances, but it certainly means it can be exercised in those named circumstances.
But as I understand the point that's made against you, the point is that section 124.1b, in a sense, presupposes that there will be an appeal. It doesn't clearly say you can make provision that there should be no appeal. And so anything in section 124.2 is just explaining what orders you might in particular put in place in relation to appeal, which has to exist.
Yes, and if that is the submission, it's wrong for the following reason, that it would mean that a time limit could never be placed on an appeal, because it would always mean that if the person didn't comply with the time limit, they lost the right of appeal.
Well, you say, insofar as any ambiguity, 1242 covers it. A
Yes.
covers it, because
And
it says
it
in
is-
terms, the time within which.
Exactly. What it does, and we say this at paragraph 20 of our skeleton, it provides for a condition that needs to be met before the appeal can be made, which is a paradigm case of the circumstances in which an appeal may be made, in the same way as in Total, where the provision was you have to pay money in, otherwise you can't exercise your right of appeal. The court said, well, that's fine. The problem is just saying, sorry, you can never appeal from the first tier to the upper tribunal. It's getting rid of the right of appeal altogether. It's not saying there is a right of appeal, but to exercise it, somebody has to meet particular conditions. Otherwise, as I say, there would never be an ability to set a time limit on an appeal. It would be outside the vires of this.
Well, unless my colleagues disagree, for my part, I think on the general interpretation of the statute, we've probably taken this as far as we can with you now, but we certainly will hear how Mr Burton puts it and then give you a right of reply. But you want to take us to tell?
Yes. So it's at tab 14.
Yeah.
Paragraph 1 captures the issue, which is this. Page 354. Does the power conferred by section 124 include the power to abolish a statutory right of appeal to the upper tribunal from the decision of the first tier tribunal? That right of appeal has been conferred by the 2007 Act. So it's a wholesale abolition of the right of appeal. So the background facts are fairly complex, but the heart of the issue is captured at paragraph 11. And what the court will see is that the order that was challenged was the 2009 order, which is described at paragraphs 9 to 11. And at the bottom of paragraph 11, the court will see that what the legislation said was, notwithstanding the provisions of the Tribunals, Courts and Enforcement Act, the decision of the tribunal as to the issue of hardship is final. So there is a statutory right of appeal, but sorry, there isn't for you, basically. So it is a complete abrogation of a right of appeal. And then at paragraph 13, Lord Justice Moses says the question is whether there was power to provide that in the 2009 transfer order. This is a case about section 124. So section 124 is cited then at paragraph 15. Paragraph 17, the court directs itself in accordance with Spath Home, and that's relied on by the other side. Parliament doesn't lightly take the exceptional course of delegating to the executive the power to amend primary legislation. When it does so, the enabling power should be scrutinised and shouldn't receive anything but a narrow and strict construction, and any doubts about its scope should be resolved by a restrictive approach. Well, for the reason I've already submitted, we say there isn't any doubt in this case. And then paragraph 20, the court asks itself, Lord Justice Moses, whether a provision made for revoking the right of appeal from the decision of the first tier to the upper tribunal, so nobody enjoys the right in any circumstances, no matter how quick off the mark they are, is that a provision in connection with appeals against HMRC decisions? And then, importantly, we say, paragraph 21, the paradigm of a provision, which is a provision in connection with appeals, is contained within section 1242. And that's to pick up on my lady's point, which is the circumstances in which the power may be exercised are expressly set out by the statute. And then, and importantly, so far as this case is concerned, the court says, just between letter E and F, the circumstances in which such appeals may be made clearly include the provisions within section 84 under the rubric further provisions relating to appeals, such as the provision requiring the tax in dispute to be paid before the appeal may be entertained. So those provisions are intra vires, and we say the reasoning is the same here. A provision which says before you appeal you need to request a review is no different in principle from a provision which says before you appeal you have to pay the tax in dispute. Both are squarely within section 1241 and section 1242 as being in connection with appeals against HMRC decisions and the circumstances in which an appeal may be made. So that that addresses the question about, well, it doesn't say to take away the right of appeal. No, it doesn't, but it does mean that if you don't comply with conditions, you can't appeal. That's exactly what's being said in paragraph 21. And the difference in Total, the reason that the answer was different for the challenge provision in Total is at paragraph 22, because it's the provision which says the decision of the tribunal is final, so it can't be appealed at all. It takes away the right to appeal from the first tier to the upper tribunal. And that's essentially what's being said at paragraph 22 and 23. That you can't use this power to totally remove a right of appeal, but you can use it to say you've got to do something before you can appeal. And that really is my answer to the virus point. I say Total answers it. It's a decision of this court in relation to section 124. And the reasoning in paragraph 21 is squarely on point. It may be that reasoning is obiter, but nonetheless it's strongly persuasive. What certainly is different about this case is the stark removal of a right of appeal altogether, which is not what we have here. So those are essentially my submissions on vires.
You just dropped in a reference to obiter.
It is obiter, I think.
And the decision was that the provisional consideration in Total was ultra vires.
Yes, it was.
And in reaching that decision, Lord Justice Moses contrasted it with with other parts of the statute, which and postulated circumstances which would not be ultra vires. And you say this case falls within that category of example that he gave.
Yes.
In drawing contrast. Well, I think my lady's right. I think it is technically obiter.
Yes, the reference to paying tax is obiter, but there is an essential part of his reasoning.
That's exactly what I was going to say.
Yes.
He has to deal with the fact that this is not in connection with an appeal. So,
yes.
So elements of this are part of the ratio, I think.
Yes, I think that's right.
Yes.
In any event, we submit it's right, and it clearly should be followed.
It is Lord Justice Moses.
It's Lord Justice Moses, and indeed a very eminent court, because Lord Neuberger and Lady Justice Arden, as she then was, both agree with his conclusion. What Lady Justice Arden adds is a very eagle-eyed point, as it's discussed, about retrospectivity and why that might be an interference with fundamental rights, but that's not, of course, our case. Yeah. But they both agree with Lord Justice Moses.
But anyway, just to nail down that point, it's not actually obiter. Well, it's part of the reasoning. The ladies.
Yes, I'll take that. I can see that it could be argued against me that it's obiter.
Well, let's see where we go.
Well, I think the reference to paying tax in dispute as an example must
it's not part of the reasoning, but the construction is part of the reasoning.
Yeah.
Yes,
Possibly.
because yes,
Subject to hearing Mr Burton.
yes, I think what I would say is, as I said in answer to a question from the court, which is one has to look at all the provisions together, and Lord Justice Moses necessarily has to look at when the provision might be satisfied, when something might be within the vires, in order to say, but this is different, it's not within the vires. But in any event, the point of the case, which is about the 2009 order stopping anybody appealing to the Upper Tribunal, is very different from the provision at issue in this case.
I'm just being slow, okay? So you'll have to bear with me, right?
Isn't.
Well, be careful whenever.
No.
In my experience, particularly the one on the wing says that.
My understanding. Can we go back to paragraph 11?
Yes.
Which is the
In total.
which is the section which is in dispute. Is that right?
Yes.
And what was actually final was the decision on the issue of hardship.
Yes.
And the hardship was a reason why you, in fact, wouldn't need to pay, is this right, the tax?
Yes.
So in other words, what they're saying is you have to pay your tax up front before you can have an appeal. Is this right? Unless either HMRC decides or the tribunal decides that that would cause hardship.
Yes.
And what is said to be final is the decision of the tribunal as to the issue of hardship.
Yes.
So it's not, in fact, when they're saying it, you characterise this as a sort of wholesale cutting off of the right of appeal. I'm not following.
I think an important part of the context which you haven't mentioned is there's an emphasis in here on the application to the tribunal on hardship is not itself
Exactly.
an appeal.
Yes.
It's framed not as an appeal. It's a reference to the tribunal.
Yes.
And that's relied on by Lord Justice Moses.
Yes, and I, because that was a point I looked at myself, that where that comes from as a starting point is in the argument of Mr Beale, who was representing the taxpayer, and that is at page 351G. What he argues, and it explains why Lord Justice Moses says what he does, is the abolition of a right of appeal is a fundamental right. Now, the court doesn't agree with that, but then he says the first-tier tribunal takes a de novo decision. So the abolition of the right of appeal removes any appellate structure from this particular jurisdiction. So as my lady says, that's why in other bits of the decision there is a reference to the first tier decision not being an appeal. Effectively, what's happened is that section 3C, 84.3c, which is inserted, referenced in paragraph 11, stops there being any right of appeal whatsoever because the first tier's decision wasn't appeal, it's de novo.
The judge covers that expressly at 22.
Yes.
So you may be... the way this works is, if you want to appeal your VAT assessment, you have to pay the VAT up front.
Yes.
So nobody's saying you can't have an appeal, there's just a condition attached to it.
Which is precisely the same as
Right.
here.
But the point they were actually dealing with is whether a decision to waive that requirement in a case of hardship, or to remove that requirement in the case of hardship, could be appealed.
What they were dealing with was a provision which says the decision of a tribunal on hardship is final, and therefore you lose the rights that you would have under the 2007 Act.
Well, if the tribunal says we don't accept that it would cause you hardship, then you can still have your appeal against the original decision.
But you'd have to pay
you just
the
got to
fine.
pay the money.
I think the confusion is between two different appeals.
Yes.
Lord Justice Moses is saying you've removed any right to appeal the refusal of your hardship application.
Yes.
Did you have a right to refuse? Sorry, did you have a right of appeal against the refusal of your hardship application as a matter of right or otherwise? I mean, nobody's saying that there isn't a right of.
Well,
Nobody's saying there isn't a right of appeal against your tax decision.
That's a separate appeal.
Yeah.
yes,
Separate decision.
but in my submission, so far as this case is concerned, and so far as the point that it is ultra vires the enabling power in section 124 to provide for a condition of requiring a review before a person can appeal, the comments in paragraph 21 are entirely applicable. It's not so much about whether there is or isn't a right of appeal, it's about vires, and there is vires to prescribe a condition before an appeal can be brought.
Right. That's again that submission I understand.
Yes,
I think you were
that's-
making. I think you did make one or two slightly broader submissions. I think, unless I misheard you, or they came at me so fast that this was to be distinguished on the basis that this was a wholesale removal of a right of appeal.
Yes, that is my submission.
But it's only a right of it's only a wholesale removal in relation to the waiver of a requirement for an actual right of appeal.
It's the removal of a right of appeal in relation to a decision on hardship.
Yeah. At this point, I mean, I'm not making a point against you. I'm just trying.
Yes,
I'm just trying to understand how far your submission goes about what this case actually decided.
we would say the niceties don't matter. In short, what this decision does is distinguish between placing a condition on the ability to appeal, but keeping the right in place, and saying, in whatever way, in whatever circumstances, sorry, this right of appeal is gone, you can never exercise it in any circumstances. And that, we say it decides both, and so far as the second point is concerned, it can't be exercised in any circumstances. That is absolutely not this case. What this provision does, section 38(1)(a), is say you can only appeal if you've sought a review. So I do make both of those points.
Yeah, or, as you said to me earlier,
Time limit.
time
Yes.
limits.
Yes, exactly.
Yeah. Okay. Right.
So I'm sorry if I'm racing ahead, but those are my submissions on vires.
Okay. So now, what do you want to say about Article 6?
Could I just make some points of context about Article 6?
Yeah.
We stand by what we've said in our skeleton. Could I just draw out 5 points by reference to the facts, and then I'll see what Mr Burton says. So I can be brief because they're points I've already made. The first point is that on the 25th of March 2019, and bearing in mind this is about process, procedure and access to a court, on the 25th of March 2019, the respondent was given a Section 17 notice and required to respond to it. So the system builds in at that stage a chance to respond. Mm-hmm. The second point of context is that then when the final notice is sent out, in this case on the 30th of April, there are a further 30 days to seek a review. The third point of context is...
And sorry, between that first date, on this case,
25th of
March,
March,
is there a built-in statutory limit, or is it just you've got to come back by the time the notice tells you to come back? I think it's the latter.
Can I check that? We're checking.
Okay.
The third point of context is that, as I've shown the court, the legislation gives an opportunity for time to be extended further in section 21B, and it's not suggested that there's anything inherently contrary to Article 6 in those criteria.
This is the special circumstance.
Yes, and as we say, there can't be any complaint about imposing time limits per se, because the jurisprudence of the Strasbourg court says time limits aren't just permissible but important, and we've set that out in our skeleton at paragraph 31. And I would add as a point of context that absent some kind of time limit, a requirement to seek a review wouldn't have any teeth, and it would leave an administrative decision open to challenge indefinitely. The fourth point of context that I would make is that, yes, a mistake was made in this case in the Section 21B decision because it was contrary to HMRC guidance. But overall, and this is likely to be something that we would want to address in evidence, the criteria in the legislation and HMRC's guidance provide ample opportunity for a person to seek a review. And then finally, the final point is this, that if HMRC wrongly refused to extend time as they did here, then certainly on the facts of this case, judicial review would have been an adequate remedy.
Would have been.
But that's the question. If we're looking at the system, the fact that somebody didn't exercise it doesn't mean that there isn't a system in place for effective access to a court.
So it would be no part of HMRC's case to say that judicial review was inappropriate because somebody hadn't followed the appeal process that's provided.
No, because there isn't a right of appeal. We couldn't say you should have appealed.
Or indeed, well, sorry, or put it more accurately, you focus on the mistake being made in the Section 21B decision. We've already canvassed it earlier this morning about the mistake being made earlier. But is it any part of HMRC's theory that judicial review is not available where somebody has failed to ask for a review in time?
Well, the challenge would be to any refusal to extend time, and judicial review would be the right remedy because there isn't a right of appeal. What would then happen is if the judicial review was conceded or granted, the person would then have their statutory appeal on the facts, if it got that far, because...
There would be the mandatory consideration first.
Sorry?
There would be the mandatory reconsideration first.
Yes, so what would happen, as Mr Burton rightly points out, it might not get to a point at all, because if the JR said, well, you should have extended time here, or the point was conceded, then HMRC would then withdraw its decision, make a fresh decision, and then, as Mr Burton points out, conduct the review, and there might not be a need to go to appeal at all. But to the extent that there was, there would then be the statutory appeal.
Mr. Burton, or the respondents say that JR is a blunt instrument, or that it doesn't meet the gravamen of the problem.
Yes, but that's certainly not correct on the fact of this case, because as I've accepted, the decision didn't even give any reasons, and appears, if one reads it, to have been saying you've applied beyond the 13 months.
But the judicial review, you say, can only apply to, or can only kick in relation to the decision about extension of time.
Yes,
it can't apply to any earlier part of the process.
No, but the earlier, what one has to remember, that the telephone conversation didn't result in any kind of challengeable decision.
No, the decisions are the giving of the notice under Section 17 or Section 18.
Only the Section 18 notice. So it's not,
right. If
an error is made at that earlier stage, but somebody responds to the Section 17 notice, it may well never feature in an appealable decision.
So if there's a Section 18 notice given which is erroneous,
yes,
then you say judicial review doesn't lie.
What will happen is the person will either apply in time for mandatory reconsideration, in which case no issue, or they apply for mandatory reconsideration late, and if HMRC says, well, we're not going to extend time, it's against that decision not to extend time that a person can apply for judicial review.
So the focus of judicial review is always on the decision about extension of time.
Yes, exactly. Then once that judicial review is either settled or resolved, if it gets that far, because in a case like this, it's likely, as has happened here, there were a simple factual mistake, it would come to light, or HMRC would look again at its decision. What then happens is, if time is then extended, HMRC looks substantively at the decision. If it changes its mind about the decision, then everything's sorted, everybody's happy. If it doesn't, then there is a right of appeal to the tribunal at that stage on all issues of fact, because one of the points we made in response to the other side skeleton was that it was conflating two different decisions. In saying judicial review isn't appropriate because there's an argument of fact, miss the point that if the challenge or an asserted challenge, even a pre-action challenge on the time issue is successful, then there is a right of appeal on the factual points. And we say judicial review is entirely a suitable remedy for the extension of time decision. And we also make the point in our skeleton that to the extent necessary, even in judicial review, if it's needed to respect Article 6 rights, there is an ability to consider facts. But so far as simply the time decision is concerned, we say judicial review is an adequate remedy. What the Strasbourg case law doesn't say is you must always have a right of appeal in all circumstances. So that's really where we are. I suspect there won't be a great deal more I could say, but obviously I'll see what Mr. Burton
Let's see what Mr.
says.
Burton says. Okay. Anything else you want from Ms. Smythe? Thank you, Ms. Smythe. Yes, Mr. Burton. It's 25 to 1 in case you were wondering. So
I'm grateful, my lord.
clock's wrong. Stopped.
If I may, the way I was going to approach my submissions is in the following manner. First of all, I'm going to confirm what the target of the challenge is in the case of any ambiguity. I didn't realise there was any before today, but insofar as there is, I just want to confirm that. And then I'm going to set out, in brief terms, what our submissions are on Upper Vires and on Article 6. Then you take me to the authorities, where I'll spend a little bit of time, because that's really where the answers lie in my submission, before coming back to those submissions and just making them good. I would hope that will take me about an hour and a quarter.
Okay.
Insofar as I'm going to deal with my learned friend's points this morning, I'll do my very best. But you will have noticed already that this case has evolved somewhat. We had the decision of the Upper Tribunal, which focused very much on the provision 1A or 38(1A). My submissions will very much be focusing on the enabling power. My learned friend has already made her points about how the enabling power is sufficient and gives vires for 38(1A). Obviously, I'm going to address that in the course of my submissions to you now. On Article 6, our case in a nutshell really is that insofar as obviously the provision is ultra vires, it also constitutes a breach of Article 6. That may only be relevant for this reason, that my learned friend appears to suggest that even if the amendment made by virtue of 38(1A is ultra vires, there's no remedy available. If that's the case, then the court would be required to then make a declaration under Section 4 of the Human Rights Act. But insofar as you're against the respondent on the question of vires, there is still an outstanding point about compatibility with Article 6, which I'll address you on in due course.
Are you going to say anything about the construction point?
Absolutely.
Okay.
The majority of my time is going to be spent on the construction point and what the cases tell us about how this court, or indeed the court below, ought to have approached it. Let me set it out this way if I can.
Right.
So the issue raised by the appeal is essentially our contention that Section 38(1A, read in conjunction with Section 21A and 21B, the Tax Credits Act 2002, is ultra vires the enabling power in Section 124 of the Finance Act 2008, because if HMRC is right about the proper interpretation of 1A, it prevents an appeal lying to the tribunal where an application for review of the relevant decision is made outside of the 30-day time limit and time is not extended by HMRC. You will have picked up already that the Upper Tribunal in CJ held that properly construed amendments introduced by the 2012 Welfare Reform Act in pursuance of the same policy but in respect of DWP decisions did not have the effect of removing the right of appeal to the tribunal where time is not extended for a late review request. And that is of some relevance to my submissions, as I'll develop in due course. The submissions we make are on ultra vires the following.
All right, just take them a little more slowly if you would mind.
Please.
Absolutely, I apologise. So as I indicated a moment ago, I'm going to, if I may, put these in outline in the first instance,
Yes.
and take you to the authorities, which I hope make them good, and then come back to clear up any ambiguities that arise specifically in this case. So the first submission is that the right of appeal in section 38 is a fundamental right.
All right.
As indeed Judge Scolding found at paragraph 29, and we take support from that proposition from the cases of Salim and Connor, which are in your bundle.
Which you're going to come to.
Indeed. And in the course of doing that, we will also distinguish what was said about fundamental rights in Total. The second point is that the combined effect of the mandatory reconsideration procedure in section 21A(b) and 38(1)A is an interference with that fundamental right. Again, relying on the judge and the decision in CJ and Connor to make that good. And therefore it follows that that infringement must be either expressly authorised by a provision in an Act of Parliament.
Right, just take this slowly if you wouldn't mind. Expressly authorised in a provision of a statute.
Indeed, or arise by necessary implication from a provision in an Act of Parliament. And we take that proposition from the Salim case, which itself is based on various cases decided before then. The critical aspect of that realisation is, rather than the crucial wording being the words used in 1A itself, the crucial words...
By 1A, you mean 38? 1A.
I do apologise, yes. I'm using that as shorthand. If that's unhelpful, I apologise. 1A being the subsection 1A being the target of the challenge. So we say the consequence of this being an interference with the...
Well, you see...
Sorry, you started a sentence
Yes.
and I didn't...
You didn't finish it.
You said
Yes.
rather something like...
The crucial aspect is not that the crucial words are in section 38(1)A,
But indeed
But-
in the enabling legislation in section 124. That's where the court's focus ought to be and needs to be.
Right.
And in particular, one must look for express authorization or necessary implication in order for the interference with the fundamental right to be vires. So the third submission is the interference is plainly not expressly authorised by an Act of Parliament.
You mean by section 124?
Indeed. Which is in sharp contrast to the position in CJ and the Social Security legislation, where the interference was indeed specifically and explicitly provided for in the primary legislation, albeit not the interference that DWP contended for. Come on to explain what that means in a moment, but it is an important fact that whereas we have a general power in section 124, in the Social Security Act 1998 we had a specific power introduced in pursuance of the same policy, which was nonetheless found by the Upper Tribunal, at least, not to have the effect intended for in this case, namely that if you are late in your application for a review and time is not extended, you've lost your right of appeal in a final way. They're not expressly authorised. And then the fourth question is whether or not it arises by necessary implication of application of the enabling power. Our submission is that it does not, and we will distinguish the obiter in total, which effectively, on my learned friend submission, construes section 124 as permitting condition precedents to the exercise of a right of appeal. We say even if that's correct, it doesn't provide the vires for this particular interference with this particular fundamental right. And obviously I'll make that submission good in due course. Alternatively, fifth submission, And I preface this by saying, insofar as this is a different question from that which arises under the fourth question, I'll explain why I caveat it that way in due course when we come to the authorities. The introduction of section 38(1)(a) was not a lawful use of the power because it was not necessary to interfere with the fundamental right to the extent provided for in subsection 1A in order to achieve the legitimate aim of the policy.
Just say that again. Not lawful because...
Not a lawful use of the power, the enabling power, because it was not necessary to interfere with the right to that extent in order to achieve the legitimate aim of the policy. And in support of that, we will rely on the decision in CJ as adopted by Judge Scolding in this case, and indeed some of the observations of Mr Justice Swift in the Connor case. The question of whether or not this interference arises by necessary implication of section 124 and whether or not it's a lawful deployment of the power under section 124 can be addressed in one go or as two distinct questions. The authorities approach that issue in both of those different ways, but we will say whichever way you approach it, you reach the same answer. So those are the 5 submissions that we will make in relation to ultra vires. In relation to Article 6, I've already made the point that obviously if the subsection 1A is ultra vires, then it must be a breach of Article 6. And Article 6 is there only to assist with remedy, should we get to that stage. However, if the court does accept that in fact Parliament did intend that the right of appeal should be lost if somebody doesn't make an in-time application for a review, we will say that that nevertheless constitutes an incompatibility with Article 6. For the first reason, which mirrors the arguments we'll make in relation to the 4th and 5th question under ultra vires, because it's a disproportionate interference. It doesn't need to go as far as that in order to achieve the legitimate aim of the measure. Those aims would be equally well achieved if you had a similar outcome as to that which we reached in CJ. Yes, you have to ask for a review in order to have an appeal, but if you don't request a review in time, you don't lose your right of appeal altogether, effectively. Our second argument is...
Just on that first one.
Certainly.
The point I think it's been put against you is that we can't form a view on whether it's a disproportionate interference unless we've got some evidence, or at least the HMRC would want to put evidence in that they say is relevant to that question.
Yes, I of course have heard my learned friend on that. I'm going to try to address you more specifically on that point when I get there, but I can sort of headline what I'm going to say now, if that would assist. What's decided in CJ and is adopted effectively by Judge Scolding, albeit applying her own experience below, is 2 components to, as it were, the proportionality or the reasonableness of the measure. The first is the one I've already mentioned a moment ago, which is you don't need to go so far as to take away the appeal right altogether to achieve the legitimate aim of the measure, which is to try and ensure that fewer decisions go to appeal because they're sorted out at the second bite of the cherry by the HMRC, effectively. The second reason is, well, it's going to cause hardship because you are going to prevent people from having their substantive issues ventilated before a tribunal. We say that still stands in the context of this particular measure, even in the context of HMRC decisions, and just as a question of logic. Some people are going to miss the time limits even though they've got meritorious claims, and the Respondent is a classic example of that. But the second aspect, if you like, of the second issue that's highlighted by CJ and by the judge below, and appears to be the nature of the objection from my learned friends, is that the particular cohort of people who are applying for tax credits is not the same as the cohort of people who are seeking other forms of social security payment and can't necessarily be considered to be as vulnerable or as afflicted by impairments which might in some way prejudice their attempts to pursue their rights through the MR process or indeed...
Sorry, is that a point made in the revenue skeleton?
Indeed, no, it's a submission my learned friend made as I understand it.
No, they've not been made this morning. So that's why I asked.
Oh, well, that was my understanding, but perhaps it was...
No, just to be clear, what I said was that's precisely the sort of point we would want to explore in evidence. I can't say what we would say in evidence because we haven't had an opportunity to do that.
I understand that, and that's
Okay.
a very fair intervention by my learned friend.
I may be misunderstanding something here. You said, yes, you accept that it's a legitimate aim to have a review process, as I understand.
My lady,
As I
yes, and
understand it.
Connor supports that.
But that you shouldn't lose your right of appeal altogether. That's not necessary part of achieving that legitimate aim. What do you actually mean by that? Do you mean simply that the question whether you should be allowed to proceed out of time should be capable of appeal, or should you have an open-ended ability to ask for a review out of time? Can I clarify exactly what your case is? Because the result of the Upper Tribunal decision is that the first two is asked to decide whether an extension of time is merited.
Yes. Because there are a number of different aspects to that. Now, if I can answer
If you're going to cover it later, and it's better, please do that. It's
I understand. So on the first question of what would need to be done to render this system overall proportionate, as respondents, it's not necessary for us to descend to that level of detail. There are a number of different ways in which one might achieve a proportionate outcome. The one that's been settled upon in the context of social security, and the one that clearly the learned recorder below had in mind, was that even if your application for a late review is refused, you can still then bring an appeal to the first tier tribunal. So you're still required to ask for a review, and obviously if you ask for one in time or time is extended, the decision maker will carry out that review, and that may get rid of the need for an appeal, either because it will address all of your concerns or the decision will be overturned. If that's not the case, if you're not afforded that opportunity, or more specifically, the HMRC is not afforded that opportunity, you haven't lost altogether your right to bring an appeal. So that's one way it could be done.
Sorry, and just to clarify, are there any time limits on bringing that appeal on that route?
Yes, 13 months is the long stop time.
So it all comes within 21B.
No,
that's about an out of time.
Social Security.
So all I'm now doing, just to be clear what I'm describing, is where we've ended up in the Social Security legislation. May or may not be the answer.
I think that 13 months is baked in the... You've put something in your skeleton about this. It's in there in the Social Security rules. But I'm having difficulty I want to understand what your case is on this appeal. You say you don't have to make your case out, but that doesn't mean we don't have to think about it.
So the logic of why I said that is this, that if we establish that it's not necessary in order to achieve the legitimate aim to remove altogether the right to appeal even if you've made a late out of time request for a mandatory reconsideration, then how you fix that problem is potentially open-ended if you're in the arena of human rights in Article 6. Conversely, if we're looking at the ultra vires question, if we're right that subsection 1A is ultra vires, it goes, effectively, by one means or another. We'll come on to the mechanism we utilise for that in a moment. The consequence of that is we do revert back to the previous practice, which is there is no longer any mandatory requirement to seek a review. It's gone. You can, of course, seek a review, and if you do seek a review, the HMRC is required to decide it. And, of course, the informal practice, which existed for a very long time before, which is the moment you issue an appeal, the HMRC will effectively treat that as a request for a review and review the decision to see whether or not an appeal is necessary, will carry on taking place.
Okay, and where's the time, and just so I understand how that works in the architecture, where are the time limits for that appeal to the tribunal? If you've
Can I first tell you what they are, and then I'll turn my back to get the actual provision, but I know what they are. They are, it's 30 days to issue an appeal. The first tier tribunal, which of course is the same time period for requesting a review. Time can then be extended, I think, pursuant to regulation, rule 5 of the rules, and I'll come on to that in due course, it's covered in CJ, up to a long stop of 13 months from the decision, because you get an extra 12 after the first month. So, my lady, where the confusion may have arisen below is in the following way. If I ask for a review after 30 days, then if I've also got an existing right of appeal, imagine that world for a moment because it's ultra vires, I'm also out of time for my appeal.
Yes.
If I'm subsequently denied the right for a mandatory reconsideration out of time because of a 21B decision, under the vires position, I could still go and ask for an appeal as long as I'm within the long stop of 13 months. But then the question is, does the first tier tribunal have to consider whether to extend time pursuant to Rule 5 to allow the appeal to take place? Now, the obvious answer might be to that. Well, obviously, time would be extended. It's a very general open power because you were trying to ventilate your rights elsewhere, i.e. through the mandatory review process, potentially. And that means it would come back to the tribunal, and the tribunal would then say, well, we'll entertain...
Okay, but the tribunal might or might not. I mean,
Yes.
I'm just trying... what I'm getting at is your sort of a... I'm probably putting it too strongly, but your assumption that the net result is that you get in front of the tribunal to have a consideration of the merits. And I'm just trying to understand whether that actually is the case.
My lady, the answer to that does depend on whether we get there through vires or whether we get there through Article 6. That's the first point to make. But the reason is that under vires, 1A goes, so we go back to the previous position, which is you just have a normal right of appeal.
Yes, but the tribunal might itself refuse an extension of time. Anyway.
Yes, yes, and that doesn't come within the purview of this case necessarily.
Right.
I was just positing one possible outcome might be the same one as the FTT appears to have taken in this case, which is, well, because you've been undertaking this process, trying to ventilate your rights elsewhere, will grant an extension of time for the appeal, the right to which you've never lost, according to the decision of the Upper Tribunal.
Okay.
I mean, strictly speaking, you have a right to apply for permission to appeal out of time.
Yes, that would be more accurate. Yes, and my understanding is that's what the judge below was trying to achieve in her second direction.
Right. So that it's the tribunal considering a late appeal, whether to entertain a late appeal.
My lady, exactly.
Okay.
But obviously in circumstances where part of the reason you're late at least
is you've been jumping over a hurdle that shouldn't have been there.
Indeed.
Then you'd say you would anticipate, but you can't guarantee that the tribunal would give you an extension of time.
You can't, but the critical point is your right of appeal, albeit subject to obtaining permission, has not been extinguished indefinitely for good. That's the qualitative difference.
Until 13 months when it does.
Indeed. But that was always the case in any event. Yeah. And that specific point is actually addressed in CJ. In my submission, nothing really rides on it. But it's exactly the same architecture, and whether you're dealing with decisions under the 98 Social Security Act or you're dealing with the provisions in relation to the Tax Credits Act, it's the same.
So you say, in fact, there's no chaos?
No, there's certainly no chaos.
Or there's no uncertainty. People can...
I can now before...
You've got 2 or 3 minutes if you want to just draw these.
Can you get, by the end of the short adjournment, references to the relevant provisions, please?
Absolutely. They are actually in CJ, but I will take you to in due course specifically.
I don't mean for Social Security, I mean for this.
Yes, I mean, they're the same rules. But.
Thank you.
Now, can you just draw this to this your preliminary exposition of your case, to draw the threads together?
Well, I was just going to tie up the point about what the learned recorder did and where the error lies, because it did seem to me that that was of some relevance to where we end up.
Okay.
And for completeness, really. So, in a somewhat counterintuitive way, we actually say that the order she made is the correct one in terms of reverting back to the first tier tribunal in order to permit the respondent to exercise his right of appeal, which she found had never been extinguished. However, the way in which she got there was to interpret subsection 1A in such a way as to draw it in alignment with the interpretation under section 12(3)(a) of the Social Security Act. Namely, that yes, you must request a review before you can appeal, but even if your review isn't carried out, because, for example, you're late, you can then appeal thereafter.
So
you're referring there to the analogies that she drew in terms of policy.
and you say that was the wrong way to get to the right result.
But the simple way of describing where we say focus of the judge below was wrong is she was looking at the wrong piece of legislation.
Should have been looking at the enabling statute.
My Lord, exactly. And I hope, obviously, to make that clear and the reasons why we say that in due course. Once that's clear, I may live to regret these words, it's our submission that the solution to this case is actually very clear and very straightforward.
Well, thank you very much. We'll rise now and look forward to seeing you all again at 2 o'clock.
All rise, disabled.